Court has upheld the constitutional validity of Aadhaar. A 5-judge constitutional bench ruled 4-1 in favour of upholding the Aadhaar Act, but some provisions have been outrightly struck down and some have been read down. The order runs into nearly 1,500 pages, and Justice Chandrasekhar has issued a separate dissenting order calling the Aadhaar scheme itself unconstitutional. But first, let me take you through the fine print of the majority verdict. The court has rejected the argument that the Aadhaar creates a surveillance state, but it also has gone on to impose crucial restrictions on data collection. The authentication data can be retained only for 6 months against the current provision of 5 years. Now, on the crucial question of privacy, the court has ruled that Article 21 protects only matters where there is reasonable expectation of privacy, and the Aadhaar Act meets the test of balancing. But the court has also made it clear that Aadhaar will be mandatory only to avail government services. Private companies cannot demand Aadhaar. Linkage of Aadhaar, whether it is to your bank account or to your mobile phone, is not mandatory. So you do not have to link your mobile phone with Aadhaar, and it's also not compulsory for school admissions and for examinations like the NEET, UGC, JEE, CBSE at this point in time. However, it will be mandatory to link your Aadhaar with your permanent account number, that's your PAN card, as well as to file your income tax returns. Finance Minister Arun Jaitley has welcomed the verdict, and when asked about the conditions imposed by the court, he said, and I quote, "There are 3 prohibited areas. We need to understand, are these totally prohibited or a legal battle is needed? We don't think that these areas are perpetually prohibited." So is the government hinting at a change to the statute to link Aadhaar linkages with bank accounts, mobile phones, what have you? We don't know just yet. And finally, in a scathing dissenting order, Justice Chandrasekhar has basically said that the passage of the Aadhaar Act as a money bill is a fraud. He's deemed the entire scheme unconstitutional. He said, and I quote, "Dignity and the rights of individuals cannot be made to depend on algorithms or probabilities," end of quote. Before we start discussing the order with our experts, here are the sights and sounds from the Supreme Court and the corridors of power on a victory that's being claimed both by the government and the opposition.
We are already saving 90,000 crore rupees every year.
The interest of the government was to collect all the Aadhaar through the private sector and then get it transferred to itself so that it could misuse it. I think the Supreme Court has nipped that mischief in the bud.
It's a very balanced judgment.
ये एक बहुत ऐतिहासिक जजमेंट है जिसमें कि आम आदमी को बहुत रिलीफ मिलेगा।
स्कूल में एडमिशन के लिए बैंक का आधार नंबर नहीं देना है, तो ये अच्छा हुआ जो आम जनता को ये प्रॉब्लम नहीं होगा।
Well, the opposition as well as the ruling party, the BJP, claiming victory on that Supreme Court order. Senior advocate Arvind Datar, one of the petitioners in the Aadhaar matter, also joins us. Mr. Datar, appreciate you joining us. This has been one of the longest hearings that the Supreme Court has had, and I believe after the Kesvananda Bharati case, this is one of the longest that the Supreme Court has heard. Now, I want to ask you, sir, what are the implications of the order as it stands today? And I ask you this in the context of what we've heard from the government so far, with the finance minister articulating that this prohibition of some linkages, whether it's to mobile phones or to bank accounts, need not be prohibitions in perpetuity, which does seem to suggest that perhaps the thinking within government is to bring in law, to add this onto the statute to try and get around this.
Well, I don't know if the government can do that, because the basic, the essential feature of Aadhaar is that it's completely voluntary. And secondly, that it is needed for grant of subsidies, benefits and services which are paid from the Consolidated Fund of India. Now, I don't see what is the foggiest connection between having a mobile phone and Aadhaar card, or why it should be linked, why every of the 1 billion bank accounts should be linked with Aadhaar. There's no reason at all. People who have bank accounts for 30, 40 years are told that unless you link the Aadhaar, your bank account will be blocked. So I think this ban should be in perpetuity because it's completely disproportionate. Even if they bring about an amendment, I think it will be very, very vulnerable to challenge on grounds of proportionality, on grounds of irrationality and so on. For example, insisting it on for your school admissions, for birth certificates, for cremating dead bodies and so on. It's completely bizarre. In fact, you couldn't go to Tirupati temple without an Aadhaar card. So all those things have to completely go. And I think even for banks, it was very unfortunate that they amended the money laundering rules to make all Indians as to link their accounts, as if every one of us is suspect. Yes. So I think even if they amend the law, it would be very, very seriously vulnerable to challenge.
Okay, you're saying that even if they were to amend the law
what I'm
to
saying
try
is you can't
and
by
get
one breath
people to link their Aadhaar cards, sure.
With every bank account, yes. Yes, yes.
Go ahead, sir.
Especially when the main purpose of the Aadhaar card is to ensure that, when the main purpose of the Aadhaar is to ensure, sorry, please go ahead.
No,
I was
just saying, sir, and I quote to you what the former finance minister, Mr. Chidambaram, has said, and he basically goes on to say that for now we can be satisfied that a rampaging government has been restrained and that the Aadhaar has been contained as was meant to be a benign instrument to provide benefits, subsidies and services paid out of the Consolidated Fund of India. So, in a sense, that is the heart of this judgment today, is it not?
Yes, it's basically that they've restricted the Aadhaar ecosystem, that it has to be narrowly tailored and focused to subsidiaries, benefits and services. And you see, you can't make the act, you can't draft the act and say it's completely voluntary and then indirectly issue notifications and make it compulsory for everything in life. That is the paradox which has to be, which the Supreme Court has sorted out now. They said that, look, if it's for subsidiaries, make it for subsidiaries. And there is no reason why it should be meant for bank accounts and so on, where already there are enough safeguards and precautions in place to ensure that there is no money laundering or no black money. The Reserve Bank has issued enough number of guidelines. So there is no purpose or logic in linking the Aadhaar to bank accounts. And frankly, I don't think a person who's going to be a terrorist or indulging in black money is going to open a bank account, link it with Aadhaar and then disclose it to the government. He's going to be outside the system in any case. Yeah, so it serves no purpose. And I've seen pensioners, old widows and so on, whose accounts were simply blocked because they didn't have the Aadhaar number.
Okay, I want to now ask you, Mr. Dattar, that what happens post this order? Because now that the court has basically struck down Section 57, what happens to the fact that we have already submitted, whether it's to telecom companies or to banks, our account details, our Aadhaar details? What happens now to the data that's already been collected by private companies?
Well, in my view, there should be a provision to road roll those data, what they call to efface or erase those data. If they have collected the data for the past 6 months from the beginning, that should be completely and should not be kept in any silo or any kind of server with the UAIDI. As far as telephones and bank accounts are concerned, that should be completely deleted.
Okay, but is that a clear understanding that the UIDAI will now be forced to do this?
Well, we have not read the judgment. You see, we do not know the fine print. The Supreme Court has said you can't link it. Now, it was linked. What happens to the period when it was linked until the Supreme Court judgment came? What happens to that data? According to me, if it is struck down, then it should be struck down from the beginning when the PMLA rules were introduced. So anything done under those PMLA rules will have to be completely wiped out, will have to go. And I don't know how the government is going to do it, but they should do it. In all fairness, they should ensure that all the data collected.
Right.
Yeah, please go ahead.
But, you know, just on some of the questions that the court has tried to answer, because the court has also said that while it reiterates that Section 57 does not pass muster of proportionality, it says it sees no reason to invalidate enrollments that took place before the Aadhaar Act was passed. So if you were to read that in the context of Section 57, you know, how would you place this?
Well, I think that enrollment is a slightly different thing from 57. 57 basically permits the state to permit private companies to use their Aadhaar authentication, and it also permits the state to enter into contracts with private companies. That has been struck down. Now, the enrollments have taken place before the Aadhaar Act came into force. In fact, the Aadhaar Act came because one complaint was that you are asking millions of people to enroll without any statutory backing. So what the majority has said is that all the enrollments that took place from 2009, 6, whatever the date is, till the Act came into force, will not be invalidated. They will continue to be valid. Otherwise, then the whole thing would have to be redone. So all the people who have enrolled before, their numbers will continue. They will not be invalidated. Yes. But that's not a Section 57 point. That's the point that what has been done in the past. That's a Section 59 point where what has been done in the notification.
Absolutely.
Yes, yes.
You're absolutely right. That's not a Section 57 point. But before
so what was
I let
done
you go,
by
Mr.
executive
Zidane,
notifications?
let me ask you this. Sure. Where does this leave things now, sir? Because the court has very clearly said that you need to A, put in place a data protection regime, and B, appropriate amendments will also have to be made to the Aadhaar Act, given the fact that the court has struck down several sections. What would you now see in terms of the next steps?
Yes. I think in that sense, the judgment is partly work in progress. They have made sure that certain things cannot be done. They have also issued some directions. We don't know the details, but they've issued directions to the government, as you put it, to ensure data protection, to make sure that there's no surveillance and there's no profiling and so on and so forth. So those directions will now have to be complied with by the government within a time frame. I don't know if they've mentioned a time frame, but a lot needs to be done now by the government to ensure that the Supreme Court directions are implemented in both in the letter and spirit.
In letter and spirit. Arvind Datta, I appreciate you joining us here on CNBC TV18, one of the petitioners, counsel for the petitioners in this matter, joining us here to make sense of the Supreme Court judgment and its implications. BJP MP from the Rajya Sabha, Rajeev Chandrasekhar, also joins us. Also with us, Sanjay Swami, former volunteer with the UIDI, is with us, and Mishi Chaudhary, founder of SFLC.in, and Napinai, cyber law advocate, also with us. Appreciate you joining us here on the program. Nandan Nilikani tweeting, this is a landmark judgment in favor of Aadhaar. More than just opining on the constitutionality of the Act, the Supreme Court has unequivocally validated the founding principles for Aadhaar. Aadhaar is a unique identity project that is critical to the developmental goals of the nation. Rajeev Chandrasekhar, that might very well have been the idea with which Aadhaar was founded by the UPA and which was taken forward by the NDA, but somewhere along the line, Aadhaar seemed to have become this sort of one-size-fits-all approach that the government took, link everything to the Aadhaar card. That basically has today been reined in, at least for now, by the Supreme Court.
No, I think I don't want to comment on what Nandan has tweeted, but I think the Aadhaar that started in 2010 without any legislative backing, without any scrutiny, without any debate, and the Aadhaar that we have now post the Supreme Court judgment are two very, very different Aadhaars. There is, as you know, in 2016 we had a legislation. In 2017, the Supreme Court found that the private privacy is a fundamental right. And today, the Supreme Court has upheld Aadhaar's constitutionality.
Section 7 and 8.
Also affected some of the imbalances in the Aadhaar Act that many in the civil society were arguing against, ranging from Section 2B to 47 to 57. So I think where we are today is an Aadhaar that has evolved. It is clearly here to stay. The fight on the leakages and corruption in the public subsidy spending system is going to be taken on squarely without all this political wrangling. And at the same time, the real issues that were at the front and center, which was the lack of trust between UIDAI and the citizens that had crept in because of this unilateral sort of powers that were given to UIDAI under the Aadhaar Act, have been, in my opinion, rebalanced and corrected as a consequence of this judgment.
Okay, rebalancing has happened post the Supreme Court judgment. Of course, we're still awaiting to hear from the UIDI and from the government on how it intends to pursue this rebalancing. But let me bring in Sanjay Swami. Sanjay, thanks very much for joining us. Section 7 and Section 8 of the Aadhaar Act being held to be constitutional by the four judges of the Supreme Court. Justice Chandrachud, of course, dissenting, saying that this whole scheme is unconstitutional. But this business of the government forcing people to link Aadhaar to virtually every kind of service. I'm looking at what the court has said. For instance, should schemes involving children mandate the requirement of Aadhaar? And the court unequivocally saying that the requirement of Aadhaar card cannot be mandated on children to supersede the right to education. Also, when we talk about whether it should be linked to bank accounts, etc., the court once again stating very, very clearly that linking bank account details of a person to Aadhaar is violative of the right to privacy. Presumption of criminality is arbitrary. Nobody would keep black money in their bank accounts, and hence it cannot be mandatory to provision a linkage of bank accounts to Aadhaar. So would you agree with Rajeev Chandrasekhar that essentially what the court has done is to go back to the UPA era of what the Aadhaar was meant to be, with constitutional sanctity, suggesting that whatever is being given out through the Consolidated Fund of India, what is linked to the Consolidated Fund of India, that is being linked to Aadhaar, and that has been held up. But private companies, the use of Aadhaar by private companies, that has not found constitutional muster.
Wow. Sorry. So Shireen, thanks for having me on the show. As you know, I am a technocrat, and I actually was really excited today to see my understanding of the verdict. It's still early. It's a 1,600-page document. But I think I just wanted to point out,
yes,
4 or 5 things that stood out for me, and then I'll get to your question in a second. I think, as Nandan has tweeted as well, it is fundamentally upholding what unequivocally sort of validating the founding principles of Aadhaar. A few points that I've noted. One is, yes, it is absolutely establishing uniqueness. It is inclusive. It is secure. It is for residents and not just for citizens. It does not establish a proof of citizenship. It's a proof of identity, which was what we have always maintained.
Yes.
It's an unfakeable ID. Cost of verification of ID is very, very high in the industry. It's empowering. And lastly, the savings are real. I think that part, all of this has been validated, right? So that's definitely, good news and a very strong validation of the Aadhaar program and its value to the residents, right? We put the residents at the center and said, this is what they're getting out of it, or we are all getting out of it. The second part here is that, yes, I think where all can it be used? Certainly in the government programs, because, it was initially, benefits were a big part of it. There are savings. The savings are real. It should continue to be, and it's okay to make it mandatory. That's also very clear. Yeah. When it comes to the other regulated entities, again, because KYC is mandated by law, they should be able to do Aadhaar-based KYC. I think that's also quite clear, whether they are private entities or PSUs or government entities, because KYC is required by law. I believe there what will end up, what we're looking at here is a limited KYC, where you can do the KYC but not save the Aadhaar number. And then for private, it's not saying anything. It's basically struck down the provision, but effectively my interpretation of that is that it is voluntary. If I'm coming for a job application at your agency and I share my Aadhaar as my proof of ID, it's entirely fine for me to share Aadhaar as a resident and for you to accept it as a proof of ID, but it's not mandatory. You can't mandate that, this is the only ID you can use. So broadly, I think given that 98% and more of the adult population have Aadhaar, it will end up being the most convenient form of ID, but in these few cases, it can't be mandated. When it comes to children and certainly some of the other examples, yes, I think we're looking at it practically, saying, look, they have a right to education. They should be allowed to not have Aadhaar and still get a schooling and things like that. Absolutely makes perfect sense, that's allowed. I think over a period of time, people will just realize the value and the convenience and how easy it is to get services with Aadhaar, and it will become the voluntary choice rather than being mandated.
Mandatory. Okay, so that's
so I
your
think
belief.
overall,
But let me bring
it's
in
a really positive ruling, and a few guardrails are being put in place.
Okay. a few guardrails are indeed being put in place. Let me bring in Enes Napinai into the conversation as well. Thanks very much for joining us. Just in terms of some of the guardrails that the court has in fact put in place, it said that there is no need to retain authentication data for 5 years, 6 months is sufficient. It's asked for that change to be made. I want to go back to the point that Swami was making, that this business of Aadhaar being voluntarily, presented by people to their mobile phone companies, job employers, and so on and so forth, as opposed to it being mandated. Now, what happens in the case where through these various circulars, etc., this data has already been provided, whether it is to banks or to telecom companies, for instance? The court also suggesting in its ruling that there is no statute in place for banks and telecom linkages as of now. So perhaps the government may consider bringing in a law in order for us to be able to do so. But in the interim, what happens if someone doesn't now want that data to be accessible to their mobile phone company or to their bank?
Thank you for having me here, Shireen. You're absolutely right. It's a very, very valid question, which is top of the mind for everybody. So now, I've heard everybody else talk about the various aspects of the judgment. One reservation is, what Sanjay just mentioned about it being voluntary in terms of presenting. The voluntariness in terms of accepting or applying for Aadhaar, unfortunately, has been taken away by upholding the linking to the IT returns and the PAN card. So that is still an issue. So this is like a mixed reaction from both teams, where we from the petitioner side feel that the court has gone substantial mile, but it could have gone much further. So that's one aspect. The second aspect is what you have rightly pointed out. So now what happens because the genie is already out of the bottle? How are you going to put it back into the bottle, and how are you going to ensure that any undertakings or statements made by a corporate entity are a true reflection of the situation? So for that, there are multiple pieces that have been moving with respect to data protection and privacy. The first being the Puttaswamy judgment, and then the Sri Krishna committee and the draft that has been presented. And now this judgment has come out, which has categorically set to rest many aspects, reservations apart. Today, I think the corporates should not be lax in waiting for the draft bill to become an enactment. There is already sufficient provisions under existing law which mandates the basis for consent as a prerequisite for receiving personal or sensitive personal data, and as what is mandated under law or a contract. So now that the law has been struck down, the very basis on which they collected the data is over. So I'm being very specifically adverting to Section 43 and 43A of the IT Act. So we are not living in a vacuum today in terms of law. So there is a provision which says that you can do it as a law or a contract, but you have to comply with the terms. If this is struck down, or rather since it's been struck down, then the corporate will necessarily have to delete the data they have collected on erroneous basis that they were entitled to do that, and they cannot any longer read the other data or anything that was consequent to the other data, which could even be biometric.
Okay. I just want to point out for the benefit of our viewers, because as everyone's pointing out, it's an almost 1,500-page order. So why is it that the court has said that you cannot, it's unconstitutional to force people to link their bank accounts and their mobile phones to Aadhaar, but it's okay for the income tax returns and PAN cards? The court basically has upheld the validity of Section 139AA. It says it needs to be examined in the context of privacy being a fundamental right. Linking of Aadhaar with the PAN card will enhance legitimate collection of the country's revenue, and hence there is every justifiable reason to link PAN with Aadhaar, and hence Section 139AA meets the triple test of the right to privacy, and this is why it is upheld linking the Aadhaar with PAN but not with mobile phones and bank accounts. Let me also bring in our other guests here with us. Thanks very much for joining us, Shrimi. Very quickly, let me ask you what... we've also got Pavan Dugal with us. Shrimi, let me very quickly ask you what you believe are the next steps now, and what are the implications of what we've heard from the Supreme Court judgment today? I'll get to you in just a second. Pawan, let me put that question to you.
So what's your specific question, please?
Implications of the judgment today as it stands.
Implications are it's chapter 1 done, which is to say constitutionality well established. Bigger implications is how are we going to deal with the cyber security of this entire issue. Merely because Aadhaar is constitutionally valid does not mean it's cyber safe, it's cyber secure, it's cyber resilient. A lot of work needs to be done. Ideally, it would have been much more better if guidelines would have been given to say what all further needs to be done. But having said that, I think there's a lot of work for the government to do. Not only in terms of trying to see how to actually build up a new order after Section 57 have been struck aside, in terms of ensuring how private companies will go ahead in terms of deleting, destroying or scrapping data from their networks, and how to ensure that the said things are appropriately audited. But more significantly, going forward, when now Aadhaar is going to be targeted by state and non-state actors, the issue is how can we make Aadhaar, which is India's critical information infrastructure,
Pawan, just 1 second, Pawan. I'm interrupting you because we have with us the architect of the Aadhaar, Nandan Nilikani, joining us from New York. Nandan, appreciate you joining us, and thanks very much for taking the call early in the morning. You know, I would imagine that this is a significant relief and victory as far as you're concerned, because you had envisaged Aadhaar to be a way to plug leakages within the government system and to improve efficiency of providing citizens with government services. So in that sense, Section 7 and Section 8 being held to be constitutional by the Supreme Court, victory you consider?
Well, certainly this is a landmark judgment in favor of Aadhaar, and I think what's really good is that apart from upholding the constitutionality of the Act, the Supreme Court has also upheld and validated the founding principles of Aadhaar, which is that it is a project for development, that is a project for inclusion, that it allows millions of people who have been left out to become part of society. So, and the resident is heart of the project. So I think in that sense, the court has also upheld the founding vision and idealism of the Aadhaar project.
Yes, the court has certainly upheld the fact that this is a project that has been able to efficiently deliver and empower citizens. It hasn't allowed the exclusion argument to get in the way. But Nandan, do you believe that somewhere in the last few years, the founding principle of why Aadhaar was needed, why it was necessary, sort of lost its purpose? It went rogue, so to speak.
I think that we have had healthy discussion and debate over a decade on Aadhaar since I joined the government in July of 2009. So I think it has undergone huge scrutiny. It's been looked at from all sides. I don't think there has been any other project in India which has had this level of sort of scrutiny and so on. And I think what we have at the end of it is a stronger and better Aadhaar. So I'm very pleased with the outcome.
Okay, in terms of a stronger and better Aadhaar, and what we've heard from the court today, for instance, the court saying that it's not necessary to retain authentication data for 5 years, 6 months is sufficient. Also, the court basically reading down and striking down certain sections of the Aadhaar Act. How would you, what do you believe have been the highlights of what the court has said on what should be improved upon and what should be the amendments that the government should make to the Aadhaar Act?
No, Shireen, I'm sitting in New York. This judgment happened at 3 in the morning for me. So, and it's a 1,000-page judgment. So
yes.
You will have to pardon me on this. It's time, I really cannot comment on all the various sections and the fine print. I will definitely have a look at it and see what it is. But overall, as I said, it's a landmark judgment in favor of Aadhaar. It upholds the principle of inclusion that animated the whole project, and I'm very pleased with the verdict.
Now, I understand that you haven't had a chance to look at the fine print, so I won't, I'll try and keep my questions broader. But on the fact that Section 57, which deals with private companies and them being able to access Aadhaar for various services, that has been struck down and has been held to be unconstitutional. What does that mean, Nandan? What kind of implications do you believe that that is likely to have?
Again, as I said, I need to look at it further, but I would broadly say that I think any application of Aadhaar which is going to provide conveniences to 1 billion people, I think they will happen in some form or the other.
What do you mean that they will happen in some form or the other? Do you believe that there will need to now be amendments brought into the Aadhaar Act to ensure that that does happen? Those linkages are allowed to go through?
No, again, as I said, I don't want to get into this, discussion because there's too much that I don't know about the judgment. But I think, the fact of the matter is that everyone knows that this is an inclusion project, and I think the court has upheld that. And if 1 billion people can open a bank account in 2 minutes with the Aadhaar eKYC, I think people will realize the value of that and find an appropriate solution.
Okay, find an appropriate solution. But Nandan, let me ask you now, because we still don't have a data protection.
Within the law.
Within the law, but the law currently doesn't allow for the linkage as per the Supreme Court's reading.
No,
but
again, I think we need to look at the 1,000-page verdict.
No, the 1,000-page verdict essentially says, and again, I point out that there is a window there because the court is saying that there is no statute to allow for the linkage, and perhaps that is where the government sees an opportunity to try and provide for the statute to provide for the linkage. And so, I don't believe that it's necessarily a closed window, but of course, these are matters for legal experts to opine on. But Nandan, we still don't have a data protection regime in place, and the court has also made it clear that the need of the hour is to put one in place. The report is in, recommendations are in from the Sri Krishna Committee. We don't know when we're going to see that law being finalized, but do you think that this needs to be now dealt with a sense of urgency?
No, I completely support and endorse the suggestion that we need to have data protection and privacy law as soon as possible. As you're perhaps aware, I was the first person to raise the need for such a law in May of 2010 when I wrote to then Prime Minister Dr. Manmohan Singh. So I've been arguing for more than 8 years that we need a law, and I think the Justice Sri Krishna Committee has done a wonderful job in framing the law, and I think I'm all for passing it as soon as possible, but I'm not the person to do that.
Yes, you're not. And in fact, this is in the dissenting order, Justice Chandrasekhar very categorically saying that the absence of an independent regulatory framework compromises data protection. And you're saying that you believe that this ought to be done with a sense of urgency. But Nandan, if we're saying that Aadhaar is a work in progress, it has evolved today, you believe that post this judgment, we will have a better, stronger, more robust Aadhaar. What are the next steps besides putting the data protection regime in place that you would like to see being taken forward?
Yeah, I think data protection, passing the law, creating a data protection authority, creating the necessary checks and balances for privacy, all that obviously is a very important thing going forward. And now also looking at the judgment and looking at the current architecture of Aadhaar, what needs to be done either in a legal manner or regulatory manner or in a technology manner to make sure everything is aligned. And that I'm sure will happen.
Do you think that...
I need to go.
Okay, one final question before I let you go. Were you nervous this morning? About which way this would go, given the fact that this has been one of the longest hearings that the Supreme Court has sat in on after the Keshwananda Bharti case.
Not at all. I was confident that truth will prevail.
All right, Nandan Nilekani, appreciate you joining us. Nandan, the architect of Aadhaar, did it under the UPA, and that's been, of course, taken forward by the BJP and the NDA. Appreciate you joining us here on CNBC TV18. Pawan Dugal, appreciate you staying back. I interrupted you for that conversation, but now that you've heard what Nandan had to say and what we were discussing, a quick take from you.
I think this is a landmark judgment, very well welcome. So the portion of legality of Aadhaar is now behind us. The issue is, let's move on to the next chapter. The next chapter is, what are the chinks in the armor? How can we make Aadhaar more secure? How can we make sure it's not going to be targeted by state and non-state actors? And finally, how can we make it more cyber resilient as part of India's national critical information infrastructure? And for that, I think a lot of onus is going to be on the government. It's going to be on various other stakeholders, and everybody has to contribute in making Aadhaar as a central lifeline of India's progress and India's thought leadership in the area of national biometric identification systems across the world.
All right, Mishi, let's get you to take that conversation forward now in terms of the safeguards and the guardrails that need to be put in place post the Supreme Court verdict and what you make of it.
Well, I should perhaps go have coffee with Nandan and discuss it here itself about what he thinks. Anyway, what I do think
you should do that.
Yeah, exactly. We're in the same city, so I might as well actually have a discussion. What I do think is that I know you've had a lot of chance to talk about what the details of the majority opinion have been. I think it is important that the scope has been curtailed. It's great when a judgment comes up, which is 1,448 pages, and everybody takes a victory lap. That tells you there's something for everyone.
Yeah.
If Nandan can celebrate it, if the petitioners can celebrate it, if the government also says there's far more once you start foraging through all these verbiage out there. I think very important about limiting the scope, this mission creep which Aadhaar became, and also this touting of it as a panacea, that has been checked, and that's a great thing.
Yeah.
Section 57 getting struck down, that is a very important part, and also the court recognizes that what we were trying to do is once you give access to every kind of a private party, then you cannot control those private parties. And also, there are no fundamental rights which are enforceable or available against these private parties. So all these eKYC companies, the wallets and the financial companies, everybody who was out there to make money, or new startups which sprung up because everybody's data is whatever the new petroleum, oil, whatever they want to use these days. And in fact, it's dirtier than how we have used petroleum, and you see how where we are now because of that usage. So anyway, I think that check has been a very significant part of this judgment. I also think that why the majority says that despite all the issues, we don't want to throw the baby with the bathwater, is a recognition of the fact that no longer can UIDAI or the government or present or past architects of this program just wave their hand and say, you know what, there are no leakages. You know, there is no problem at all here. And this, if we are really serious about all of that, that there is a capability of using our tech and globalizing it, then you cannot make naive claims like a centralized database will never be hacked. It's now important, A, to get real about technology. B, every company, every large data company, whether you talk about the Googles or the Facebooks of the world or anyone else, makes sure that their vulnerabilities are something which people can report to them so they can plug those vulnerabilities. That's why they offer bug bounties to it. So I think it's time that we get mature, that UIDAI says, yes, I understand there are problems here of tech. This is no longer about my trying to be the nanny state and shut everybody who is in dissent down. Why don't you help us make it more robust and better technically? Because it's going to be used for.
I know Sanjay's. Okay, I know Sanjay is waiting to jump in on this. So Sanjay, very quickly respond to the points being made there by Mishi that, you know, there was a certain amount of mission creep, Aadhaar being positioned as this panacea for all, and that has been reined in, that has been checked by the Supreme Court verdict today, and that there needs to be a greater degree of acknowledgement on the part of the government as well as the UIDAI that there are real problems that require fixing. You know, you can no longer have this ostrich approach or this defensive approach to say, all is well and all is good, and that perhaps is also an indication of what the Supreme Court is saying. Again, the Supreme Court saying that, look, you didn't come to me, we're not holding you in contempt, even though you continue to issue circular after circular. So the court has given a little bit of leeway to the government and the UIDAI on that front. But, you know, the point that Mishi is making, that there needs to be an effort now to put a much more robust system in place, and defensiveness is not the way to do that.
So I think right from the beginning, and if you look at the Aadhaar program and, you know, how several of us from the private sector were volunteers and have continued to be volunteers working, I think UIDAI has always actually worked very progressively and, you know, constructively with several people from the private sector to try and make this a very robust system. We all acknowledge that technology keeps changing. I'm not speaking on behalf of the UIDAI necessarily, but, you know, I think broadly, you know, there is a channel to engage with them, and I think it's a good validation so far. You know, I think that they've clearly said that there haven't been any breaches so far, but you know, it's encouraged to work constructively with the outside world and you know, make this a very robust system, which I totally agree is the right thing to do. So broadly, I'm very comfortable with you know, some of those points as well. I did want to come back to the question of, you know, people who felt that they have mandatorily, you know, been forced to give up their Aadhaar for their bank accounts. And so if you think about what information was given from Aadhaar for the bank accounts or from for the telcos by linking the Aadhaar number, it's really name, address, date of birth, gender, phone number, email address, and photograph, right? All of which you would have anyway given the telco, except for the Aadhaar number itself, right? So I think what's going to happen, or what would look practical, would be where it is not mandatory to do the linkage, is to actually just de-link the Aadhaar number, not delete all the other data, because that was anyway KYC data that had been you know, presented, which you had anyway previously also presented, and just de-link the Aadhaar number from the record. And I think so it's really not that big a deal, I think, to carry out the you know, for all those who are concerned about, well, I already gave my Aadhaar, what's going to happen now? I think there are some practical solutions that are going to come about. And given that many of these are regulated bodies, they will be, you know, given a certain time frame in which they should comply. So I think residents can be quite comfortable that you know, is not much to worry about, and it will get, you know, cleared up with time.
Okay, Rajeev, let me ask you then, in terms of next steps now, when we see that law being put in place, we don't know, but the next steps on part of the government as well as the UIDAI, what would you like to see?
No, so here is the thing, and I want to just pick up on a few things that some of your panelists talked about. I think one of the things that we must come to, which is a dramatic, different approach from what Nandan and his gang was building a narrative for the last few years, is this whole data is the new oil, this whole narrative that had gotten so far ahead of fundamental issues like consumer rights and consumer protection. There's a break that's been put on that. Data is not the new oil. The data is going to be given for the absolute minimum requirements of the data fiduciary. It is not going to be this, you know, heaven on earth where all of these people play around with terabytes of data and create these businesses and entities on top of it. So that fundamentally is the difference between the so-called vision of Aadhaar before and what the reality of Aadhaar is today. Point number one. Point number two is, as an ongoing evolution of stronger consumer rights, a data protection law is absolutely important to make all of these data fiduciaries act in a responsible manner to whatever minimum data they collect from the consumers. And that is why the Justice Sri Krishna report's draft is a good starting point. I have already commented on it publicly, that it is a good starting point. It recognizes a number of fundamental principles about data protection, but the bill is not yet there. I think we need to have a decent, detailed, reasonable conversation about what the future of data protection law should be. It should not be like what we did to Aadhaar in 2010, which is rush it in with a lot of spin and hyperbole. We should reasonably build a data protection law, which is really going to be almost like a written constitution of the digital economy as we build it looking forward. So these are the two things I would stress, which is that data is not the new oil in India. Data is essentially an enabler, a minimum enabler in a relationship between the government and the citizen, and the private parties here do not have a role in this at all. If they do have a role, it is going to be absolutely on mutual consent and consent driven, and not mandatory as was the case in the original Aadhaar. And like I said, data protection, that is where the focus now should move to, for a reasonable conversation on this, minus spin, minus all these corporates running around creating all this, drama. This is to do with.
Are you really hopeful of that? I mean, the spin continues even today, Rajeev.
The discourse on the data protection
the spin.
Are you really hopeful of that? The spin continues even today. The spin continues even today. I mean, whether it's the government, it's the opposition, it's people who've been involved with the project. The hyperbole continues even today. So I can see Mishi is nodding her head vigorously, and Sanjay's smiling away, as is Pavan Dugal. But Mishi, I'll give you the final say. A much more measured approach is what Rajeev Chandrasekhar is advocating. Don't rush into a data protection law that we will need to unwind or have to deal with its challenges. But how would you now like to see us move forward, given the context that we're faced with?
So yeah, I was nodding because I love it when everybody seems to agree that everybody has won, no matter what side they argue. So it's anyway. What I do want to say is that I think that the adage is overused, obviously, whether it's petroleum, oil, whatever. I think it is important that everybody has realized the importance of it. That's why you see the Reliance Jio changed the market completely by offering what it now offers the Indian market. I also think that's why we are not looking at who else is collecting all this data, and whether the regulator actually has to now come up and talk about every entity. Now, my organization, we've been petitioners in this case since 2012, and after that also 2 matters we represented. But what my organization has been working on the data protection bill, it is a good start, but it is only a start. If the endeavor is going to be, let's just pass something and then wave it in everybody's face to say, oh, we have a data protection, and now it's going to be, again, it's like a Band-Aid, right? Retrofitting solutions later on. Right now, September 30th is the last date of comments. I urge everybody who's been actually hurt by this in one way or the other because of the mission creep to at least pay a little bit attention on what's going on there. One problem is that we are not concentrating on making it simple and easy for users. Your viewers, if they're not experts, they should still be able to understand what is being happening with their data. If they want their data to be deleted and they want to be opting out, they should have an easy mechanism to do. They should not pay lawyers like me, or they would not have to rely on technical experts of anything. I personally think that this entire business of private companies acting as volunteers in any of the government things really is something which we should not encourage, because there is sunlight is the best disinfectant. We need to have more clarity about who's working in what capacity. I don't think that serves anybody. I think one important thing is that we are protecting people. We are not protecting data. So data protection, data this, etc., is not going to help us. We need a framework.
I think you've hit the nail on the head, that in this quest of data protection, etc., we must not forget people, we must not forget the consumer, and I think that was the point. Yes, go ahead.
So there is just one thing I wanted to add to this. Whichever way the other judgment is looked at, we now have 2 very robust judgments on data protection, which is the Pakistani and now the other one, where the courts have already set out very elaborately what are the tests to be applied for an enactment. So with this wisdom in hand, I think it would really behoove the government and the legislature to apply their mind to any draft, because I do have my reservations about the draft which I already voiced extensively. day earlier. So before they rush in, not just the points that have been raised, but to also keep in mind that which has been highlighted by the Supreme Court as a basic necessity or a fundamental requirement of an enactment. You know, it would really help us if they keep that in mind and then redraft or relook this bill. That way, we don't have to have another 30 plus days of hearing on another enactment.
No. I hope we don't. But I think there is consensus on the panel that while each side claims victory, the need of the hour is to sit together and to identify the issues that require rectification and to keep people and the consumer at the heart of the conversation. I'll use this opportunity to take up from Mishi and whoever needs to send in their ideas and suggestions. September 30th is the consultation timeline, so please go ahead and do that. Rajeev Chandrasekhar, Sanjay Swami, Pawan Dugal, Mishi and NS Napina, I appreciate you joining us here on CNBC TV18 with your thoughts on the Aadhaar verdict that's come in from the Apex Court today, all 1,500 pages of it. It's time now for us to head into a break. After the discussion, we'll be joined by Abhishek Manu.